with pleasure and pride, I announce that Institute of Objective Studies, New Delhi, is organizing a book release ceremony today on 12th of November 2022 in this afternoon. The book is edited by Professor Zafar Mahfooz Nomani Saab, who is the Professor of Law in the Department of Law, Aligarh Muslim University, Aligarh. I invite Professor Muhammad Zafar Mahfooz Nomani, who is the editor of the book, to introduce the book and give the main points why you have selected this topic for this publication.
Today is a book release function of the book. The title is Equality, Justice, Fraternity in Contemporary India. In fact, the genesis of this book is primarily the Institute's deep commitment to the constitutional values, the constitutional morality, the transformative constitution, which we talk of. We generally say that it's not enough that we should have the government, but we should have a good governance also. So similarly, we also talk of that we should have a constitution, but having a constitution will not be enough unless we have constitutionalism, unless we have the constitutional morality. If you look at the constitutional development in contemporary India, there are certain spectacular changes which are discernible, and that pricks every reader or every student of the constitutional law and law per se, and even the general public, to ponder upon. The first thing is that in 1973, the judiciary, with its highest bench, constitutional bench, has come out with a judgment known as Kesavananda Bharti versus State of Kerala in 1973. So that was the phase with the enactment of the Constitution, 1950 to 1973, a 23 years period, or we can say roughly a kind of a period of a quarter century. The judicial experiences of the justice dispensation in this country led the Supreme Court to believe that there is a basic structure. And the doctrine of basic structure, which has been propounded in Kesavananda Bharti's case, has been one of the celebrated and one of the cardinal principles of constitutional law in this country. The background happens to be very simple. The background is that the founding father of our constitution and large number of people and our leaders who have envisioned India into a secular, democratic republic, socialist, secular and democratic republic, then judiciary at least had a pause and thought that there will be a generations of legislatures who, in their pursuit of power, may try to amend the constitution in such a way, though it will be called an amendment, but it will be going to change drastically the very face of the constitution. Therefore, as a student of law, when we peruse Kesavananda Bharti and its aftermath, then it is said that the power of amendment of the constitution, which has been laid in the Golaknath's case, is not to liquidate the identity of the constitution. And the parliament and the legislature is not supposed to act as the liquidator of the constitution, and they have a solemn constitutional duty under the oath of the constitution to protect and defend the constitution. Thereby, the basic structure of the constitutions cannot be amended. This was a kind of a catharsis. This was a kind of introspection. This was a kind of a feeling of the Indian judiciary of its experiences of working of the Constitution in a quarter of century. Then we have from 73 to 90s, a kind of a phase where the public interest litigation acted as a gravitational pull to confer those rights on the people which were hitherto not defined within the precincts and the boundaries of the Constitution of India, meaning thereby that no person shall be deprived of life and personal liberty except the procedure established by the law when it was called upon to be interpreted by the Supreme Court in Maneka Gandhi versus Union of India. Justice P.N. Bhagwati, Chief Justice, as then he was of the view that the life means that all goes along with and a dignified life, and then that interpretation of the Constitution which has given a widest possible amplitude to the metaphor and the vocabulary of the right, and thereafter the judiciary have taken it as a fundamental parchment and the document, and then started reading all the rights which have been conferred under the directive principles of a state policy. For example, the right to education, right to work, right to livelihood, right to environment, right to Panchayati Raj, right to health. And then they try to read these rights as a concomitant and a part and parcel of the Article 21. And then a time came that through the liberal approach of the Supreme Court, be that the judicial activism, be that the judiciary was called upon to act as a bulwark of the democracy, has interpreted these rights within the meaning and interpretation of Article 21. And a classical example of this fact is Article 45 of the Indian Constitution, which erstwhile was envisaged that a state shall endeavor, a state shall impart free and compulsory education to all children below the age of 14 years. And then that right was made fundamental right, and Article 21A has been added by the way of constitutional amendment, and it has made a fundamental right. So right to education, which were the part of the directive principles of the state policy, has been made a fundamental right, and as well as it has been made a fundamental duty. And though the language of the Article 45 stands corrected and changed now, and wherein it has been a duty of the parents to foster and provide adequate opportunities of their children to grow educationally. So the upshot of the argument is the judicial vicissitude of the interpretation of the Constitution has been to accommodate more and more fundamental rights within the chapters of the fundamental rights, or especially Article 21, Article 14, and Article 19 of the Indian Constitution. The present volume, which is reflective of the fact that the journey of 1973 post Kesavananda Bharti's case, the journey of post Maneka case, and the journey of the judicial activism of the Supreme Court, which has emerged as a new avatar in this democratic country to save the rights, to confer more and more rights, which were quite unarticulated, and has read the nature and content. It refurbished the entire nature and content of the right. Now, the Supreme Court is reeling under a kind of a feeling that the basic structure which has been laid as a part of the German Constitution is not visible in India. And therefore, the Supreme Court has found an equivalent metaphor to protect the rights of the people, and that equivalent metaphor is constitutional morality. So we must have a constitution, we must have constitutionalism, and we must have the innate sense of the constitutional morality. And then that constitutional morality demands what the title of the book is: equality, justice, fraternity in contemporary India. Because Dr. B.R. Ambedkar, the founding father of the Indian Constitution, have envisioned a society in India which can be called in one word, and that word is egalitarian society. If we can understand the etymological senses, if we understand the import of the words of egalitarian society and the classless society, I think that I shall bring home the conclusion to the audience and the panelists simply because of the fact that the Supreme Court have recently come out with a judgment wherein it has upheld the 10% reservation to economically weaker section belonging to the upper caste of this country. And that judgment have triggered a new debate about that reservation is for equality or reservation is to sustain the interest of a particular minority or minority in power or minority who has been subjugated, be that scheduled caste, be that scheduled tribe, be that backward classes, be that other backward classes, be that the class of people who have a lower income, but the people who belong to the upper strata, upper caste of the society. Because the Constitution of India, like the Indian Penal Code, does not have a chapter of general explanation where it has, in a succinct manner or in an unmistakable term, has defined who is backward, who is minority, who is scheduled caste, who is scheduled tribe, who is marginalized people. Therefore, everything is left open and wide open to the interpretation of the Supreme Court. And Supreme Court, through its edifice and the rampart, time to time try to find new ways and meaning. The concern of the book is simply that over the period of the time, the feeling of otherness and the feeling that some of the citizen, which has been the kind of the feeling which this book subsumes, is a kind of a feeling which has been very popular, and that feeling is nothing short of the entire voluminous report of the Sachar Committee in 2 volumes. And then when Sachar Committee report was allowed to be executed, then there was certain problems, and that problems has given rise to 2 more committees. And one was the Diversity Commission report, another was the Equal Opportunity Commission report. So taking the cause of the backward classes, the marginalized people and the minorities, we should take a very holistic perspective of the Sachar Committee report and Diversity Commission report, Amitabh Kundu report, popularly known as, and the Equal Opportunity Commission report of N.R. Madhava Menon Committee report, popularly known as. If we take these 3 reports and we try to get the gist out of it, then the idea is that why is it so that in the process of development, some of the section of the people are lagging behind, and the section of the people who are lagging behind is not the onus of their backwardness, that whether they are backward, the onus of their backwardness lies on the state. That is the Equal Opportunity Commission report and the Diversity Committee report unequivocally spell out that the onus of the backwardness lies on the state, and a state should act as a balancer and equalizer to the fact that why the cake of development have not reached to these section of people, and then the evidence-based advocacy that why a particular section of the population is reeling under some kind of a deprivation is a subject not by the community, is a subject not by any organizations, articulations or advocacy, but it is subject that the state should meaningfully engage into it. And one of that aspect always happens to be that when we talk of justice, social, economic, and political, and then if you read the preamble of the Constitution, then ultimately says that the fraternity, because the fraternity is a kind of a question which may not be a legal question, but the question of the fraternity is ethical. The question of fraternity is always a very fundamental question right from the civilization, because unless we have to inculcate the feeling of the brotherhood, unless we try to imbibe the human values, unless we respect, foster for the others, unless we cherish the diversity of this country, unless we try to keep the person who are in the margins to the mainstream, then the Constitution will not work. And that's why the Ambedkar in his book have rightly pointed out that the fraternity is something very important, is a kind of a means and a sense of common brotherhood of all Indians. And let there be a kind of a feeling, and because of some of the development which happens to be here and there, and happens to be very disturbing, that raises the question that whether we can address squarely the question of fraternity. The question without fraternity, equality, and liberty will be no deeper than a coat of a paint. So this is the word which is very impregnant. And what Ambedkar says, that without fraternity, equality and liberty will be no deeper than a coat of paint. And this speaks volume of the things that why the question of fraternity has acquired a center stage, and that transcends all kind of the mundane barriers of the religious and the casteist and the regional kind of a feeling, and all kind of the obscurantism, to lead some kind of a liberational values to allow this Constitution to work. The other thing which I will just conclude about the volume, that the volume per se tries to have some kind of a feeling that the Constitution of India is not, even if it has been to be very lengthiest, even if it has been very comprehensive. If you say that Article 14 is there, if you say Article 21 is there, if you say that you have a fundamental freedom under Article 19, if you say that you have religious freedom under Article 25 or 26 of the Constitution, if you say that you have Article 29 and 30 which protects the minority, the Constitution of India, despite its solemn affirmations and conferring the rights of the people, is not a self-executing document. And therefore, it requires an executive machinery to read the Constitution and to implement the Constitution and translate the ideals of the constitutions. And that's why the working of the India's Constitution since last 72 or 73 years clearly demarcate that we require a strong enforcement of the Constitution and the constitutional values. This volume, which consists of the 15 papers and which is primarily a kind of international seminar which is being scheduled by the Institute of Objective Studies, and some of the papers of that seminar and some other papers are also taken into that volume. I think that volume is not something like very sacrosanct and is not going to be a magnum opus, but certainly will try to buttress the debate that over the period of time, the question of equality, justice, and fraternity in contemporary India have assumed additional significance. And this book tried to give this message. And I am thankful to Dr. Manzoor Alam Sahab and Dr. Muhammad Alam and the office bearer of the Institute of Objective Studies to have thought of. And there's another book which is on the annual that talks about the judicial accountability. I hope to complete it very soon as the papers are completed. And I wish all the best to the Institute. And I do look forward for further debate on those issues and look forward to propounding thoughts of the panelists, of especially the Professor Eqbal Husain and Professor Z.M. Khan, and Professor Hasina Ashia about the volume and the audience. Thank you very much, one and all. Thank you for patient hearing.